we got to talk about this body cam footage. It's my own personal stuff, but it is very much legally related, and it's kind of funny. It's really funny to me. People have been trying to get my body cam footage from the day of my arrest. I would prefer that they don't get it. My wife and children are on there, and tons of private stuff around our house is included in that footage, and it just doesn't really belong in the public eye, in my opinion. And the law is so thoroughly on my side that it's really embarrassing that it's even going on this long. Nonetheless, Josh Moon of Kiwi Farms has employed a lawyer to try and sue the county and sue everybody except me to get the footage. And they ate a hard loss today. And they ate a hard loss in the exact way that I told them that they would. But I'm the worst lawyer on earth, so no one listens to me, and that's fine. It's funny that the first big L that Kiwi Farms has really taken in court came from the worst lawyer ever, and expect some more of them, Josh. We'll do a little bit of a deep dive into the body cam footage decision, and I'll try and explain procedurally where everything is, because this is actually really complicated. Josh was very sneaky in how he did this, and I have a lingering suspicion that they may have someone inside the county helping them out with some accidental classifications of documents and data. But that being said, that's pure speculation at this point, and I don't have anything to back it up other than the frequency by which stuff in my cases just happen to have these mischaracterizations, and they got leaked. And when it happens once, you go, okay, well, that's a mistake. When it happens 3-4 times, you start to go, what's going on over there? But we'll talk about that. I'll show you guys the law on it. It's very clear. Like, it's not even close. And like, Josh is throwing a temper tantrum, which is funny because he's like, I'm gonna get that footage. Okay, Josh, that's great. And maybe he will. I don't see the legal avenue for him to do it, and I'll show you why in the ruling that was written today. It was a bad ruling for them. It happened in the morning, and I've been having a pretty good day because of it. You want things to go the way the law is supposed to go, especially when the law is on your side. And what you don't want to see is the bullshit that got two people, it got two people to unlawfully view this footage. And when I say unlawfully, I mean on the part of the county. The two people didn't do anything particularly wrong. Although the lawyer requesting it, Matthew Harden, has made some questionable statements before the court. And if he keeps them up, he may have to account for them. That's not a threat from me. It's how court works. He seems to be trying to do anything he can to keep the people who are in the video from having a say in their own private data being released. And then also, he seems to be obscuring the fact that he's representing clients specifically, which prevents, the analysis of those clients and whether or not there's an existing conflict or any sort of other issues. It also messes with the ability to confront the people who claim to be involved. Matthew Harden is claiming his own personal interest in this body cam footage while he's not making any attempt to see it.
Been spending most of my life chasing drama in the online strife. The courts, they block my site. No body cam footage here tonight on the farms. Most of my life, fat soft boy eyes ain't got no why. Judge said, no, you ain't right. Harder than Drexel's roast that night.
Damn. Yeah, the body cam footage is going to continue to elude null. People have asked me, they're like, well, are you going to release it? No. Now I'm not going to release any of it. Now I'm going to be a bitter bitch about it and not even release any screenshots or anything. Fuck you. I'm going to keep it for me. I'm going to do watch parties of me watching the body cam footage while anybody from Kiwi Farms can watch me watch it, but I won't put it on screen. I'll just sit there and watch it on mute for you guys. Because I'm a vindictive piece of shit. So this dropped today. This is the big news in my life, and this has dominated my mind for the day because I'm just over here laughing with two F's, and I want to go through this. So this is a current order on a motion to intervene. So this is the case of the Nick Rekieta body cam footage. All right, some details. There's background details. There are about 9 body cams that exist. Each one is about an hour to 2 hours long, and it's from each officer's different perspective during the raid of the house. All right, so there's a bunch of these things. When I was doing my omnibus hearing, there's a section in which there's 2 body cams. I believe it's the body cam of Officer Nestor, and then the other one is the Officer Pomplin. Pomplin was the lead investigator. Now, what happens in that footage is that on Officer Nestor's camera, he's talking to April, and he Mirandizes April. You have a right to remain silent. You have a right to an attorney, blah, 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 blah. And April says very clearly, I will not answer questions without my attorney. And so at that point, the police have a duty to stop asking questions. Once you positively assert your Sixth Amendment right, they are not allowed to continue asking questions until you have an attorney present. You've made a clear assertion of it. Now, there are ways to break that. You can start talking of your own volition, but the police officers are not allowed to directly ask you questions. There could be a significant amount of time that passes, like an hour later, an officer could say, hey, did you want to talk to us or about anything now? Like maybe some new thing happens and they're like, hey, what about this? Do you want to talk to us now? And you need to politely reassert your right. In this case, Officer Nestor Mirandizes April. Officer Pomplin walks up. Nestor needs to go somewhere else. And so he tells Pomplin she has been Mirandized. She will not answer questions without an attorney present. He's very clear on this. And Pomplin says, okay. Immediately as Nestor walks away, Pomplin starts asking April questions in a custodial interrogation manner. This is unlawful. This is a violation of her Sixth Amendment right. She answers those questions. People have speculated about what she said, and that she spilled the beans or something. No, what April said was damaging to her case more than anything, because she talked about staying over here at the house, which then places her in the bedroom where there were drugs, which is why she ultimately was charged with 5th-degree possession. Okay. They should not have been able to use those statements against her because they were given illegally. That said, during my omnibus, I had planned to try and assert her Sixth Amendment rights by proxy to remove those statements and any statements that she made during that interview from the record. Those statements didn't really hurt me, and it didn't really hurt Lady Rackets, but they were really bad for April. I was trying to get those statements out. With those statements removed, she could possibly move for dismissal. And it didn't hurt me to have those statements in or out of the case. So we were prepping to try and make a proxy Sixth Amendment argument. This is not a strong legal position. The court didn't have to grant it, and didn't seem like they were going to. That said, we never actually got to this issue because my lawyer and the prosecutor just agreed that they weren't going to use those statements in my case at all. She's like, I'm not going to use those statements. You don't need to worry about it. And so rather than fighting over it, we didn't have to fight over it. We just got the issue was mooted. Now, the way the Minnesota evidence system works is in the past couple of years, they've developed this system called MINDES, and that's going to be mentioned in this order. MINDES is just an evidentiary online filing system where you can have things so that the court can pull them up very easily if you need to access and present an exhibit at a hearing or trial. So you upload things into Mindes in a pretrial status, which my lawyer did with 2 of the body cams, Officer Nestor's and Officer Pomplin's. They were both uploaded there. If, and this is a big point, if something is offered into evidence in court and the court accepts it because it has to be admissible, if those 2 things occur, now it is admitted as evidence. If those 2 things do not occur, if either one doesn't occur, like if there's no offer and therefore no admission by the court, or there is an offer but the court says this is inadmissible, if either one of those occur, they do not enter the record ever as public. They're supposed to be marked as rejected. Now, as seems to be common in my case, something happened and that was erroneously marked as admitted, even though we never offered and the court never admitted the 2 videos. So the videos then sat in this status. And there's been a bunch of talk in these cases about what happened with those videos. But the long and short is the county administrator, the county court administrator, allowed access to 2 fat women to come in and look at these videos, I believe unredacted. This is unlawful. This is a violation of the Minnesota Government Data Practices Act. This is something that I am strongly considering taking up with the county. But at this point, it's not the highest priority thing. And it's pretty bad. The county releasing those videos is very bad. Now, here's why. Each disclosure allows a plaintiff to recover for any damages that they've suffered, including emotional damages, reputational damages, etc., from the release of private data. And then there's also exemplary damages that are available for each instance. Now, the problem for the county is there are 8 plaintiffs, right? There's me, there's Lady Rackets, there's each of our 5 children, and then, of course, April would have her own claims as well. There are 8 of us who did not consent to the release of that footage, and that footage is non-public. It is private. It has never been, it never changed legal status. Like I said, there was a clerical error in how it was put into Mindes after the hearing. That's not us. Like, that's not something my lawyer could do or not do. That's done by the county clerk. They put it in inappropriately, which means they were negligent at best. At worst, they were willful. That's a whole different thing. But that said, a negligent disclosure under the Data Practices Act entitles each plaintiff to relief for each disclosure. So we have 8 plaintiffs with 2 disclosures, so that's 16 total claims. Each of those claims carries exemplary damages between $1,000 and $15,000 on top of attorney's fees and on top of economic damages, reputational harm, and all of that stuff. So I don't know if you guys are good at math. That's a lot of money. Bleezer says, lol, I love how the county clerk apparently made dozens of errors in your case. Not dozens, 3 or 4, but 3 or 4 really, really important ones in which stuff that should not have been public was made public. And we don't know if it was all the county clerk. That's part of the questions. Explain how it was public for weeks until you called White. We didn't know. It shouldn't have ever been public. And the way that Hardin filed, he didn't properly serve any of the parties in the footage because it was listed as admitted. It wasn't. He didn't have to approach it in the way of trying to get it changed from non-public to public. But it should never have been listed as admitted. Again, that's not something that is done by the parties. That's done on the back end. There's no, like, the only way we would have known is to manually go in and check. Which why would you think that that would happen? Is one of the real questions here. That being said, I want to be very clear. Hardin is acting in a little bit of a suspect way, but he's not responsible for the unlawful actions of a county employee. He's not responsible for that. And that's not the thing. What Hardin is responsible for is misrepresenting facts and law to the court. And that, I don't know if he'll ever have to deal with that. Courts kind of just are like, no, let's just resolve the issue and get it out of here. They don't really like going after people unless the misrepresentations are egregious. Although this one could cost the county quite a bit of money, so maybe they will. But Hardin represented that these were offered and admitted into court when they never were, and he was told that they weren't as well, and still represented that they were. So that, or well, his lawyer did. That's a bit of a lie. But anyway, so what happened then? And this is where things get really complicated. Hardin asked for the administrator, the GDPA administrator, to offer an opinion on the case. And they refused to offer an opinion on this case. Instead, they offered an opinion on a different case, or referred to an opinion on a different case. And they said, if these are similarly situated people, this should guide you. The problem is we weren't similarly situated. In the other case, stuff was offered into evidence and accepted. In our case, it never was. That was not served upon us. So we didn't know that this even happened. It's not like it was supposed to be served on us, but it wasn't. And they took that, and they took that file or that advisory opinion and presented it to the county. And then that's why the county released the documents, or the video, or allowed screening of it. But see, this is a big problem for the county, because the county sheriff resisted this, and there's a whole bunch of indications that this shouldn't be happening, and still someone allowed it to happen. That authorization, once we found out about it, we filed a motion, and the county filed a motion and we joined it. But the county filed a motion to have the documents properly classified as not admitted. The judge granted it immediately, and that's why only 2 people were allowed to view the body cam footage instead of 3. And the body cam footage was classified properly as not admitted, because it never was. And so that's where the status changed, and that initial case was then mooted. So the next step is what we're talking about here. And this is where Matthew Hardin, Josh Moon's lawyer, is attempting to intervene in my criminal case. And his plan was to intervene in the criminal case, which is a kind of a strange thing to do, but for the limited purpose of exercising a constitutional right. His claim was that he had a constitutional right to access the footage. And that's what the judge is going to be talking about in this order. Subsequent to this, and I know this is getting annoying, there's a separate lawsuit where now Hardin is suing the sheriff, the county clerk, and someone else. So he's suing all of them. Again, I have not been served in this, and nor have my children, nor has my wife, and to my knowledge, neither has April. And this is a problem for them anyway. You have to serve the person who has a party interest or a privacy interest in this. That's in the law. But that being said, we'll have to bring ourselves into that suit to make sure that our rights of privacy are preserved. And that's a step coming up. And people are trying to draw a distinction between this motion to intervene and that separate lawsuit. But I think as we go through this, you'll see that this is written in a way that is indicative of what's to come in that next lawsuit, and that Josh Moon will lose badly. And there are people out there, I'll briefly address this, people who are like, you should let this go. You should just move on. I can't. Like, I can't just let it go and move on. That I'm not initiating this action here. This stuff should all be private under the law. There is no legal there's no legal remedy which would make it non-private, and the arguments that they've raised about it are flatly retarded. That being said, I have to respond to it. Like, if I want to preserve my rights, I have to respond to it. So it's not something that I want to sit around and dwell on. I would much prefer this to all be over. But that said, I think the frivolous nature of this suit, I think someone owes me $6,000. All right. So we have State of Minnesota versus Nick Rekieta as defendant. This is my criminal case. Order following motion to intervene. The above entitled matter came before the Honorable Stephen J. Wenzel, Judge of District Court, based on a motion to intervene filed by interested party Matthew Harden for the purpose of asserting a right of access to evidence updated to Mendes or uploaded to Mendes. Based on the files, exhibits, records, proceedings, and being fully advised in the premise, the court makes the following findings of fact. So here are the findings of fact. On August 18th, 2024, defendant filed pre-hearing memorandum that identified the contested issues for the omnibus hearing as probable cause for the search warrant, firearm seizure, and the admissibility of a third-party statement to law enforcement. 2 body-worn cameras. Oh, it was Robbie Brannis and Quinn Pomplin. Sorry, I said Nestor. It was Brannis. Were referenced in defendant's pre-hearing memorandum in the section regarding admissibility of a third-party statements to law enforcement. Prior to the omnibus hearing, defense counsel uploaded a variety of exhibits to Mendes in preparation for the hearing. Included in the uploaded exhibits was the footage from the 2 body-worn cameras. An omnibus hearing was held on August 21st, 2024. At the omnibus hearing, defense counsel clarified that the search warrant and firearm seizure were the contested issues for the omnibus hearing. Defense withdrew its third issues involving certain statements by a co-defendant made on the body camera videos. And this is true. This was done at the omnibus and before anything happened. Raggedy Man says, I'm sorry, I'm lost. Why do they want these body cams? It's hard to explain. They want to, I guess, see the inside of my house, which was a mess at the time. Although, like I said, the mess has been a little bit exaggerated to the point where people say that, like, they say that people were like living in filth and squalor, which is not true. That part is not true. The house was definitely messy, but there was no filth and squalor there. But why do they want these body cams? People have varying reasons for wanting them, but some people just think it will be humiliating for me, I guess. And I don't know. I don't know that it would be all that humiliating for me. I don't really care that much, but it's the private space of my wife and children, and so I really don't, and they're on it, so I don't really want that out there. But their efforts are a little bit masturbatory and awkward. Vector Media says 9-year-old on coke, hedonism 2. There's no 9-year-old on coke. Hedonism 2 isn't at my house. Polycule, well, I mean, I guess DMT. I never got to try the DMT, damn it. Living in filth. That isn't true. The next part, not true. Stop this. Gross. We can get rid of you. Goodbye. Court discussed with defense counsel what records uploaded to Mendes were being offered. Defense counsel stated he was going to get rid of the first 2, which was in reference to the sworn camera exhibits that were uploaded to Mendes. The court asked the state if there were any objections. The state noted an objection only to a separate video later ruled as admissible by the court. This video was not body-worn camera video. This video was a YouTube video of either Aaron's or mine. The body cameras were mistakenly marked as admitted in Mendes after the hearing. The court did not consider the uploaded body-worn camera footage in deciding the remaining omnibus issues. So this is the big problem for Josh, is that the camera footage never, ever entered the court. On April 22nd, 2025, Mr. Hardin filed a Minnesota Judicial Branch copy request form requesting access to the footage of the 2 body-worn cameras that were uploaded to Mindes by defense counsel and marked as admitted. On May 1st, the court granted Mr. Hardin's Minnesota Judicial Branch copy request form, observing that they were marked in Mindes as admitted, but restricted their viewing only at the courthouse by appointment. And this is this is a very strange thing to have happened, because the people with the potential privacy interests were not served in this. On May 29th, 2025, the state of Minnesota filed a motion to correct court records in the criminal file. The state moved the court to correct court records to properly indicate that the 2 body cameras were never offered nor received as exhibits at the omnibus hearing. On May 30th, the court reviewed the transcript and granted the state's request to correct court records. Both parties agreed that their intent was not to offer the body camera footage marked in Mindes as received, and the court did not rely on such footage in deciding the limited omnibus issues. The Mindes recording was amended to mark the 2 body cameras videos, as not accepted, so they remain designated as pre-hearing only. On May 30th, 2025 and June 1st, 2025, Matthew Hardin filed a notice of motion and motion to intervene for the purpose of asserting a right of access to evidence. Mr. Hardin seeks to intervene to consider his briefing on whether the 2 body camera videos uploaded by defendant to Mindes are public data. On June 6th, Mr. Hardin filed supplemental memorandum in support of his motion to intervene and cited Kilmar Armando Abrego Garcia. Yes, that is the Abrego Garcia that you are thinking of, the national case that's going on right now, et al. Versus Christy Noam et al. United States District Court for the District of Maryland, civil case file 825CV00951, PX June 4th, 2025. On June 6th, defendant filed responsive memorandum in response in opposition to Mr. Hardin's supplemental authority. All facts contained in the memorandum of the court are incorporated by reference as findings of facts. Okay, so that's the court's set of facts that they're going to use to make this order. The court accepts Mr. Hardin's prior motion and filings for limited intervention for the sole purpose of considering the issue of access to records. 2, when uploading the footage from the 2 body-worn cameras to Mindes, the status box was mistakenly checked to indicate the exhibits were admitted. The admitted status of these 2 exhibits was inaccurate and required correction, and correction to the access allowed. Therefore, Mr. Hardin's motion to access 2 body camera videos in this case is denied. The court's May 1st order granting limited access to these body-worn cameras was rescinded as a result of the access request is hereby denied. The memorandum of the court is incorporated by reference, which we'll get to right now. So this is Josh and Kiwi Farms losing. That's what it is. Yeah, I see some people in the chat saying there is no public interest in this video, and that's correct. There is none. There's no dispute about what happened in the video. The police asserted that they found cocaine. I pled guilty to the possession of cocaine, all of the other substances, like everything that the police said that they did. I pled guilty to those facts. I didn't dispute them. I have not actually publicly disputed them, despite the people at Kiwi Farms, and in particular Josh, stating that I did. I did not do that. He's just literally fucking retarded, and he can't understand English. Ironically, that's actually what caused the fight between Josh and I. I had texted him, and it's like, "Hey, Josh, this is I'm saying this as a friend. You're too fucking retarded to understand like basic human interactions. And so sometimes like you don't get when people are joking, or you don't get when like a story is being told about maybe years ago and being blended with current experiences, and your brain has trouble delineating between the past and the present. And so what you do is you take things that happen in the past and you transpose them onto things that are happening in the present and vice versa, and you then draw improper conclusions." My entire messaging to Josh was like, you also live in a circle of insular retards who have a similar problem. They have a similar inability to understand social cues and to understand the English language in basic human communication. And so the thing that you're doing is generating a game of telephone that's happening with autism. involved, and people are creating false stories, and they're making them into facts in their mind because they're self-reinforcing. Kind of like how a video game journalist would write an article for two different publications and cite back to one of the articles to justify the subsequent article, right? Like, so they would give themselves their own authority. That's just how Kiwi Farms has started operating and been operating for years. And so I messaged Josh, telling him that. I'm like, you should really be on guard against this, because it's really hurting your analysis of people and what's going on. He lost his fucking mind over this criticism, and it's the correct criticism. Josh is retarded. He's dumb, and he's not unintelligent. He's just fucking idiot. And it's something to do with his like stunted social status or autism or whatever it is. He is unable to read basic human communication. He doesn't get jokes, for example. He just doesn't understand them. But that's what started all, like, the Josh and I's feud was me just, and I was trying to be nice. I'm like, hey, like your shit's all retarded or whatever, and you don't understand these things, and you should, is making your analysis, which I actually, at the time, I was like, you know, Josh and I were on good terms. And so I was like, you know, I want your analysis to be better. But he lost his mind. So now let's read why Josh is wrong. Memorandum of law. Mr. Harden requests access to the footage from 2 law enforcement body-worn cameras that were uploaded by defendant in preparation for the omnibus hearing, but never received by the court as evidence. Mr. Harden is making a limited request to intervene to access this camera footage under the premise of a common law right of access to judicial records and related access rights under the First Amendment. Mr. Harden requests leave to intervene to consider his filed adversarial briefing regarding access to the body-worn body camera footage. So the right to intervene. In this case, the interested party erroneously invokes Rule 24 of the Minnesota Rules of Civil Procedure to assert intervention rights. This is a criminal case, and they did try to use the rules of civil procedure, but it's because it's really complicated. Like, I'm not even shitting on them for this. It's really complicated to figure out how to do what they're trying to do, which is why they've tried in 3 different places now to do it. And it's not straightforward. There's not an obvious way to do this. The proper way, I think, would technically be the lawsuit that they filed, although the lawsuit that they filed has left out necessary parties, but it should be a lawsuit filed under the Minnesota Data Practices Act, and that lawsuit should involve the necessary parties of everybody who's pictured in a video. They should all be brought in to that case, because each one should be able to assert their right of privacy. The civil procedure rule does not apply to criminal matters. Minnesota's criminal procedure is governed by the Minnesota Rules of Criminal Procedure, and those rules contain no express provision for third-party intervention for this purpose. The court is not aware that Minnesota courts have addressed whether a party may intervene directly in a criminal case to assert right of access to judicial records as opposed to a separate civil filing. While normally non-party requests would be summarily denied, the court recognizes the importance of access when permitted. The court is also aware that several outside jurisdictions have recognized that third parties may intervene in criminal cases for the limited purpose of seeking access to records or proceedings, despite the absence of procedural rules adopted for that purpose. So again, even the court here is like, there's not really a way to do this, but okay, well, other courts outside of this have done it this way, so maybe we'll just do it. Those courts have reasoned that such limited interventions serve to vindicate the constitutional and common law rights of public access. See Stevens Media, LLC versus 8th Judicial District Court of State ex rel County of Clark. That's from Nevada. Public and press have the limited right to intervene in a criminal case to argue constitutional claims concerning access to court proceedings, et cetera, et cetera. Similar citations here. Despite the lack of directly applicable Minnesota authority, the court finds that it retains discretion to allow limited intervention solely to determine access rights, provided that no disruption occurs to the underlying criminal process. And this makes perfect sense. So then, and this is being done appropriately after the case is over. Right. Although a little premature, because we technically still have a time to appeal. So it's not entirely closed, which is another reason that those documents should not have been released, is they're technically still confidential because they're part of an ongoing criminal investigation, which will not end until 90 days after my sentencing. This limited intervention, however, does not entitle the intervener to participate more broadly in the proceedings or to assert any substantive claims unrelated to access. Okay, so he's like, okay, we'll let him in. That's what he says here. We're going to let them intervene for the purpose of having this, arguing this right of access. So now the assertion of the right of access is the important part, because this memorandum is going to be the exact same legal reasoning that is applied in the other case. Mendez is the newly created statewide electronic system for exhibit handling. It was developed to facilitate evidence handling based on recent changes to court appearances, allowing for remote appearances for certain hearings. This is all COVID related. Mendez requires parties to upload and exchange proposed exhibits and facilitate remote and hybrid hearings by eliminating the need for in-person exhibit handling. Parties are required to upload potential exhibits before the hearing. So the law requires this, the use of this system. The court and court staff are in turn tasked with an additional administrative requirement after hearings to electronically check whether the proposed exhibits are pre-hearing offered and or admitted. Currently, the parties are unable to withdraw their own uploaded exhibits unless they request deletion from those in court administration tasked with that authority and special access. And if I'm not mistaken, the deletion has to be pre-hearing deletion, which is kind of crazy. So that, again, this is all done by county staff, not by my attorneys. They upload it initially as pre-hearing, and then the county staff is the ones who do this. So the county staff accidentally labeling them as admitted is a county error. The Mendez system has significantly improved procedural efficiency and remote access, but has also introduced challenges, particularly where traditional courtroom practices involving verbal offers and rulings on admissibility are not strictly followed. Traditionally, exhibits have always been offered orally in court by a party introducing physical copies, followed by physical acceptance or non-acceptance after judicial ruling on any objections. This clear delineation ensured well-preserved evidentiary records. You can hear his frustration coming through here, right? Mendez, however, permits pretrial designation of an exhibit status by the uploading party, which inadvertently creates some potential for ambiguity, especially when the same formal procedures for offering and acceptance during busy court calendars are not followed. Under common law access rules, First Amendment principles, and the Minnesota Rules of Public Access to the Records of the Judicial Branch, records that are admitted into evidence and used in court proceedings are presumed to be accessible to the public unless classified as confidential, sealed by court order, or statute dictates non-disclosure, which is what happened here. Minnesota Rules of Public Access to Records of Judicial Branch 248, blah, blah, blah. It is clear that courts of this country recognize the general right to inspect and copy judicial records and documents. While Minnesota statute 13.82 and 13.825 controls the classification of body-worn camera data held by law enforcement, once that same footage is admitted as an exhibit in a public court hearing, it generally becomes a court record. At that point, judicial access rules apply. However, when a party merely uploads an exhibit to Mendez during preparation for a hearing, it does not automatically convert that potential exhibit into a publicly accessible judicial record. A proposed potential exhibit stays non-public until it is admitted during the hearing. The mere quote, the mere filing of a paper document with the court is insufficient to render that paper a judicial document subject to the right of public access. That's United States versus Amadeo. Instead, quote, the item filed must be relevant to the performance of the judicial function and useful in the judicial process in order for it to be designated a judicial document. The Minnesota Supreme Court has held that private documents generated during discovery and not filed with the court are not subject to public access. This principle supports the notion that exhibits not admitted into evidence do not become part of the public record. Quote, restraints placed on discovered but not yet admitted information are not a restriction on a traditionally public source of information. For an exhibit to become a judicial record and therefore accessible by the public, it must be formally admitted or used in proceedings. So he's laid out the rules. Now we're going to apply the facts of this case.
Josh and his users unironically believe there is some grand conspiracy by the state to protect you. The state who persecuted you is somehow Team Rekieta Kiwitrun mental illness.
It's the most retarded thing ever. Like, the state has done nothing but literally destroy everything I've built. I mean, I contributed to that destruction, make no mistake. But the actions of the state, the way they worded things and how they proceeded, did nothing but absolutely demolish my life, business, relationships, all of that stuff. The idea that the state is like on my side, and these retards are so insane. They're like, Nick's family has paid off the county. Are you kidding me? Like, what would it cost? What would it even cost to do that? Like, I don't know. But this has become like a common thing. Because people cannot fathom that, one, they have problems because I said that this was the problem with the case, and since I said it, they don't like it because I'm a bad lawyer or whatever, which is fine. I don't like, people don't like my opinions, and that's okay, right? Like, that is perfectly okay. But because of that, you know, they don't believe that this is possible. So then they go to the next options. They're like, well, then how did this happen? This can't be legally correct, so it has to be something. So now there's allegations by no one important, but there are allegations out there that my family has, through some miracle of having all of the money on earth, has paid off the county itself. That we have bought this judge and these lawyers, and somehow that has happened. I don't know. Like, I don't get it. I don't know. I don't even know how you go about bribing someone and how much it would cost. It seems like it would be really expensive, but they just cannot wrap their mind around the law. So in this matter, here we are. So applying the analysis, the footage of 2 body-worn cameras were listed in defendant's pre-hearing memorandum, suggesting initial intent to rely on the videos. That's true. However, at the omnibus hearing, defense counsel later withdrew the issue, referenced the body-worn cameras. While defense counsel may not have followed typical formalities of exhibit offer and acceptance, he indicated he was getting rid of the 2 body-worn camera videos as not particularly relevant when asked about his pre-trial exhibits in Mendez. Right. Well, there was no formality of offer and acceptance because they weren't offered. So that didn't, they asked about those. It's like, just ignore those. We're not going to use them. Even so, the body cameras were mistakenly electronically marked in the Mendez system as admitted. Subsequent correspondence received by the state and defendant and further review of the record clarified that this designation was a mistake and the videos were not formally offered or admitted. Because the footage from the body-worn cameras in question were not formally offered or admitted, they remain outside the scope of public access. An erroneous clerical marking does not transform an exhibit that was not offered nor received into a judicial record accessible by the public. And then, here we have a footnote that's pretty important. Mr. Hardin argues that mistaken temporary access requires the court to allow access. This is his Abrego Garcia. And he uses a line of dicta from Abrego Garcia, which is not holding the principle that he's trying to hold. Minnesota rules of access do not permit for access if initial access was temporarily granted in error. Unlike the Abrego Garcia case cited by Mr. Hardin, any inadvertent access was not previously openly distributed or copied. The video is only temporarily allowed to be viewed at the courthouse and not subject to copying, unlike the previous publicly marked and available documents in the Abrego Garcia case, which were later requested to be sealed. He addresses Hardin's Abrego Garcia argument here, says it's wrong. Because it's obviously wrong. It's wrong on its face, and it's so wrong that it's silly. Okay, therefore, yes, the body-worn camera footage is inaccessible under the principles of constitutional or common law access because they are non-public and inaccessible by the interested party. In summary, The body-worn camera footage in this matter is not public judicial record because it was never formally offered or admitted into evidence. Minnesota rules of public access to records of the judicial branch do not permit access in this instance. Because the body-worn camera footage is not part of the judicial record, the mistake in designations as admitted does not convert it into a public record. Therefore, Mr. Hardin's request to access the footage of the two body-worn cameras is respectfully denied. No further briefing or hearing on this limited intervention is required. That's a really, really bad ruling for Josh. Harmon Smith, you saying corrupt court just shows that you have literally no ability to read the law as written. There is no way that that was ever intended to be publicly accessible. It was a quote unquote mistake by the clerk. And their making of a mistake does not obviate the court's ability to correct that mistake. It has nothing to do with Josh. Oh, yeah, you're right. You're right. Hardin specifically says he's representing clients in the matter. So it does. Harmon Smith says, we already have a transcript. We don't need the body cam footage at this stage. Good, because you're never getting it. But that frivolous lawsuit that's been filed, I'm going to need legal fees on that one, I think. I think we might have to go after attorney's fees. $6,000 sounds about right. What do you guys think? $6,000? You haven't won anything, Nick. I mean, we won this round on the body cam footage. We'll win the next one too.
Not going to lie, as a fan, I would have definitely watched that body cam footage due to curiosity. The obsession over the cop cam is nuts, though.
Yeah, I mean, it is not unreasonable to be curious about the body camera footage. Like I fully accept that people would want to see it. And most people, it's just a curiosity, right? But the reasonable thing to do when it's obvious that you don't get to have the thing that you want is to go, oh, well, and you move on. Like that's the reasonable way to deal with this type of thing. It's like, shit, I wanted that. I don't get it. Okay, that's fine. That's how normal people deal with this type of stuff. There's all sorts of stuff that I would love to see in all of these cases that we cover. And we encounter something that is like, oh yeah, you can't get to that. It's like, shit, that seems really interesting. But hey, if it's not there, it's not there. Fen Boredom says, Nick claimed the police planted drugs in his house. I never once did. Go find the clip. Every time I ask for that clip, someone says, well, you can infer that that's what you're saying. Except you can't. You can't unless you're retarded. I wasn't inferring that. I just said the hurdles that have to be overcome in proving a possession case. They have to prove that the people in the house possessed what was in the house and that it wasn't brought in by an outside person. I never ever accused the police of planting it at all. I said, I don't consent to searches because you never know what a police officer might have on them and even inadvertently or accidentally drop or bring into a place. So you just don't consent to searches because you might be able to have the search thrown out. But that wasn't an accusation. It wasn't even an inference. It's just true. And it's the same shit I've been saying for years. So again, you don't get to just say someone said a thing. Like you eventually would have to put it up in papers in court. But even if I did, this is the crazy, wild thing that people don't seem to understand. Even if I had made that claim, that doesn't give you an access right to the body cam footage. Because that's not the public controversy that they're talking about when things go from public to private. Like that is not a sufficient public interest controversy to outweigh the privacy interests of the people involved. It just isn't. And again, I'm sorry that you listened to Josh Moon. Josh doesn't understand any of this because Josh isn't a person. He's a joke. He's a caricature. That being said, it's funny that video will never come out. It'll never happen.